Hello, everyone, and thank you for joining us. The presentation is about to begin. Elliot?
Why, thank you, Anna. Well, hello, everybody. My name is Elliot Markowitz, and welcome to today's webcast titled The Ethical and Practical Use of AI in Patent Prosecution. And this event is brought to you by law.com and sponsored by Questel. Before we begin, I'd like to go over some basic housekeeping items that will make your experience just a little bit more valuable. This event is completely interactive, and we do mean that. So if you have a question for our speaker, just type it in the Q&A field on your console, and we will get to the question either during the event or at the end of the event. Also, every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So if you'd like to change the look and feel of your console, please go ahead and do so. Just remember, the more interactive you are, the more valuable of an experience this will be for you. So please ask away and don't be shy and participate. Also, here is the information regarding CLE credits. CLE credits are approved for California, Illinois, New Jersey, and New York only. Participants seeking credits in other states must apply directly to their CLE board. The CLE code will be announced during the presentation, so you need to look out for that. New York attorneys must retain the code for their New York CLE certificate. CLE credit is available for approval jurisdictions on the date of the live event, which is today, and you must provide the date, the month, and the year. After this webcast, you'll be prompted to complete an evaluation form and will receive an email with instructions for downloading a state-specific CLE certification. So let's get to today's topic and why you are all here. Well, artificial intelligence is quickly becoming the Google search bar for a new generation of patent practitioners. Yet using it in legal practice comes with serious ethical responsibilities, as we're finding out very quickly. As AI tools find their way into everyday patent prosecution, attorneys must navigate USPTO and CFR rules to ensure their use is both effective and compliant. Well, today's webcast will offer a concise, high-level guide to ethical AI use in patent practice, drawing directly from the USPTO's Guide of the Use of Artificial Intelligence-Based Tools in Practice. Today, you will experience a live demonstration and hear real-world examples that make these rules practical and actionable, helping you keep your team efficient while safeguarding client interests. So here with us today to discuss these issues is Kevin Bronson. He's a registered patent attorney at Coulson Law Group. So take it away, Kevin.
Thank you, Elliot. Yes, registered patent attorney. I have the pleasure of working with the Coulson Law Group and also with Simpson & Simpson. I'm sitting here in Buffalo, as you can see, my Bills gear. I always tell everybody, this job that I have the opportunity to be a part of and kind of live with everybody's innovation and inventions is the third of my most important. So just a little bit about me: husband, I'm father, Wild Bills fan, love golf, as you can see back there, and I'm really taking this whole change of technology pretty seriously. I'm really enjoying it, and I want to give everybody a nice introduction how you can leverage this, either from a user standpoint or a supervisor standpoint. So let's get started a little bit here. So as all of us know, if you are a registered patent practitioner, candor and disclosure is the underlying fundamental way that we approach our discussions, our writings, anything we do with the patent office. And so we have a good faith duty of candor and disclosure. And one of these pieces packed within CFR 1.56 that we all know, we have a responsibility to convey that information to the patent office, which may be material patentability. And the reason why I open with this, we all know it from the minute we start, but this underlies all of the discussions about the AI systems that you may or may not use when you're actually effectively representing before the USPTO. Whether you're drafting, evaluating, or even if you're going to be doing actions where you necessarily aren't going to be interfacing with the USPTO, you kind of want to have this as the backdrop to do so in a responsible and ethical manner. And that's the whole goal of what we're going to do here. I'm not going to dive into each of these topics at depth, but rather I want you to be able to take away 4 or 5 really good points whether you're going to be a user of an AI system, which are popping up everywhere, especially when you have specific tools for drafting or prosecuting patent applications, or if you're from a supervisory perspective. You're running a practice, you're making decisions on the tools that your firm or your company wants to use to increase your efficiency, make you better for your clients, make better products. It allows you to know what sort of things you need to ask and what you should be expecting of those tools and what guidelines that the individuals, especially the practitioners, need to follow with respect to the ethical requirements within CFR. So I think a really good way to get started is that, you have this duty, and it applies to the use of AI tools by inventors, parties, practitioners, and material patentability. And what it ultimately does is it creates an obvious question, pun very intended for our practitioners, is did AI generate the invention or the embodiment? That is going to be the first big thing that most people kind of latch onto. Like Elliot said in the beginning, I'm a late millennial, so I grew up with the Google search bar. But our junior attorneys in your next field of attorneys that you're going to be hiring, they're not using the Google search bar like I did, or like my colleagues or classmates did. They have a LLM, a language model in their pocket, ChatGPT, something like that, and they are going to be using that to search like I would use a Google search bar. Okay, so you're looking at a fundamental change in the generation of how these attorneys are going to be interfacing with the internet and what they grew up with. And one of the big things is when you are just interfacing like that, that AI is generative. It can generate ideas. And necessarily, if you're trying to interface it to help you be more efficient with your work or understanding something, or if you're on the inventor side, so you're trying to get information from the inventor, you have to be aware that this generation can happen during the process of what exactly is the invention. So how do we interplay that? AI-assisted inventions, meaning that during the process, an inventor is conceiving an idea. There's a problem to be solved. We all know what this means. And you are using AI because it's part of your infrastructure at your company. An inventor who, a single inventor is in his garage and he's trying to think about, how do I make this better? You have an individual and she's at home and she's at work and she's using a certain product and she's talking with this AI system, maybe ChatGPT, because she realizes that there is an issue with it, or she thinks there's a way that she can make it better. Using AI does not make it categorically unpatentable. Okay. The big thing, though, is that an inventor, which you always name when you file a patent application, has to be a natural person. And most importantly, it's that person who significantly contributes to the invention as the inventor. So there was a court case from the Federal Circuit, 1998, Panu versus Low Lab Corp, and they actually created this test called the Panu factors, which are going to help you determine whether or not this significant contribution applies. And recently, we're now going to use these same rules and this same decision to determine whether or not the natural person is an inventor, and therefore you can actually file a patent application on an invention which AI assisted on. And what we have here is this significant contribution. 3 general requirements. So each named inventor, could be one, could be joints, could be a few. They have to contribute in some significant manner, and they have to meet all 3 of these. So the first is this contribution needs to be to the actual conception. What's the idea? What's the underlying aspect of it? As we know, when you are trying to identify the inventors, you're not asking who reduced it to practice, you're asking who conceived the claimed invention, okay? Here, we're not just looking at conception, but we're actually looking to reduction to practice as well. Bringing the idea to life when you're using AI is important in this circumstance. It modifies our traditional rule of conception equals inventor, because now we can look at conception and reduction to practice. If this is just words spit out from an AI model because you're having a dialogue conversation with it, you necessarily need a natural person to bring it to life or to reduce it to practice. The contribution, whether it's the conception, the idea, or it's the reduction to practice, it cannot be insignificant in quality. Um, and what that means is when you're looking at the full scope of what the invention is, normally we divide it in elements. So if we just have a widget, it comprises elements A, B, C. We are looking at whether or not this contribution is is it a majority? Is it a majority of what makes the invention work? It's not necessarily we have three elements, A, B, C, and so a natural person should be contributing to A and B, which would be a majority of the three. It's how it looks as the whole. Maybe element C is what makes A and B interface and work, right? So that requires a case-by-case determination, and it goes back to one of our fundamentals that we all have to kind of adhere to. We have to understand what the invention is. What are we looking at? What's the disclosure? And now we have to do that on an even more important level because we have to ask the question now, was AI involved in the development of this invention? Was there AI that was a part of this invention disclosure? Right? So that's where we're kind of interfacing with a change that we haven't seen before. And lastly, the inventor needs to do more than merely explain to the real inventors. It's sort of, if you have a joint inventor situation, just the well-known concepts, the state of the art, what's the background, perhaps if you're thinking about engineering or industrial applications, somebody who kind of can build the foundation for it. That is not significant. You're looking at what the real improvements are when you're talking about something that exists and you're using AI to improve it. That person that provides that foundation, that's not going to, tick that requirement. So I think the best way to do this is let's just look at a quick example here. So on the left, inventor's contribution, and then on the right is sort of a representative analysis that we should take as the practitioners when we're kind of looking at what's going on. Or in the case, if you have somebody, maybe you're an in-house counsel, so you're directly interfacing with perhaps the academics or the manufacturers or the R&D department, right? This is the sort of two pieces that you should do. So if you have an inventor that recognized the problem, okay, here's the problem. We use the tools available to us. We have an AI system that's enterprise that we can use, and it gave us some ideas. Well, that recognition of the problem, it doesn't rise to the level of conception. You didn't really do anything other than say there's an issue and how do I solve the issue? You did not conceive anything and you didn't reduce it to practice. It's a pretty simple one. We should pull it out because it's really there. The other contribution is you ended up, you're prompting them to solve it, okay? And you're developing this prompt. You know that we would go into a Google search bar, what is this measurement? What's the conversion of Celsius to Fahrenheit? Things like that. Or in this circumstance, you're going to be going perhaps to ChatGPT. You're elaborating on the problem, right? This prompt is only a restatement of the problem. There's no contribution here that can be considered inventive in how the prompt is constructed. So again, that's not going to pass. And then lastly, kind of reviewing the AI output when you're looking at what's coming back. So perhaps you have an inventor and said, well, I talked with ChatGPT and this is the information it gave you, take a look at it. You have to realize an invention without that contribution to conception is just not sufficient under these factors. So if we were to go back real quick and look at these contributions, you have to contribute in a significant manner to the conception or reduction to practice. And in our example here, you're not seeing that significant example. You need to extend way beyond this. I know this is a very simple example, but it's a really good way to just outline, what are you actually looking for to make this determination on your side? And more importantly, What questions should you be asking? Because if you're not asking these questions, you're ignoring the issue, and then you risk the fact that you're listing an inventor because they told you they were an inventor, but you didn't go farther with the discussion of the client to actually figure out how they came up to this invention that's written in this disclosure, described in your meeting. You didn't do enough to satisfy, this question of whether or not you can actually prepare and file this application. So let's look at a second example, which is going to meet the factors. That's going to work. This is actually a sort of amalgamation of something I saw in practice. It's very similar to what happened. And essentially, we had two inventors, real individuals, and they used an AI system to basically provide an alternate design for a well-known product. They saw the product, there was an issue with it, there was a problem, and they wanted to solve it. And they prompted it and they said, this is the big problem. These are the issues with the product in particular. This is what we want to kind of see if we can build. So the AI system gave them an alternative design. On my side, I was able to see it. So I was able to see what this first part was, okay? And you should try to ask that question. Well, where did it start with? What did the AI give you? Allow yourself the opportunity to review it, okay? The inventors experimented with the alternative design. And what they did is they developed a second alternative design that improved on the first. They didn't use AI for that second part. They got like a baseline improvement, and then they went above and beyond, and they actually started, making adjustments and improvements to what the AI gave them. So now they're taking it farther away from the equation. They're putting themselves in the actual driver's seat. They're conceiving and thinking of better solutions to make changes, and they are actually reducing it to practice. They built this. They created a prototype. Along the road, one of the inventors actually built an additional component for this second design. And this small piece actually improved efficiency almost by 50%. So there's another piece that they added, okay? So that's our setup here. Now, when we look at the contributions, so we basically have two, right? Created a new design based on a suggestion from the AI system. I called that the second alternative design. And then the other part is one of the two inventors created a whole different component that went to the second design, not the first design. So there's a distinction there. The first design exclusively came from the AI system, and it was prompted, can you solve a problem? This is the known product. But here, the component went to the second system, the second design, okay? How do you produce the analysis? The natural person's use of an AI system when you're creating this AI-assisted invention does not negate that person's contributions, because from asking these questions, hey, there's a second version, and we basically created the second version from the one we got from our AI system. So right then and there, you can kind of drive a wedge between the AI just giving them an alternative design versus them actually working and building and thinking of how to create a better alternative design. So that's why I always use that second step. And you want to try to see that. You want to ask those questions. If you don't ask those questions, you don't know. And then lastly, the additional component. This is an original design from a natural person. And because of the fact that it increases the efficiency almost by 50%, it's a significant element. So that right there is that is really going to ring your bells. Okay. Not only is that a new idea, so that's conception, but they actually built it. So they reduced that idea to practice. All three factors from our tests are going to be satisfied in that circumstance. And so there, you will name those two natural people as the inventors. I keep saying the natural people. And why is that important? It's because you cannot list an AI system as an inventor. And if they're the only inventor, you can't file the application because inventors have to be a natural person. So that's where it logically follows. So let's dive over into confidentiality of information. So we just went over duty of disclosure, candor with the patent office, our overall arching rules that we all have to follow. Now let's kind of get into the big main points. Confidentiality of information. CFR 11-106A, you're not going to reveal information relating to the representation of a client unless the client gives informed consent. This applies to these AI systems because at the end of the day, if you don't know where it's going, or if you're using a publicly available system, that information can be learned off of. It's not confidential. And moreover, even if you have a paid version, there are risks associated with those paid versions. Even though they say that's locked down because you have a paid and pro version, you're not necessarily safe. And we will kind of go through why the reasons are and what sort of questions you should be asking. 11-106D, you shall make reasonable efforts to prevent the inadvertent and unauthorized disclosure of or unauthorized access to information relating to the representation of a client. One of the big things is I look at is reasonable efforts here when we're talking about AI, okay? These tools are available. They can help all of us. They can improve our efficiency. Even if you don't want to use them to help generate your patent drafts or think of ideas for office actions, you don't have to. But it's a much better version of a word spell check. If you want to quickly have something, reread by, one of these systems, it's a really good way to double check everything that you're putting out looks good, or it can identify, am I saying something correctly? Does this match up? The reasonable efforts is you have to know that whatever you're doing, even if it's as simple as trying to perform like a proofreading exercise, if you put that reply in, or if you put that section of your application that you're drafting in, is it going to a place where you can ensure that it's confidential? Did you ask the questions of the provider? Is your pro version of ChatGPT on your computer that you can log into? Do you know the limitations? Is it logging prompts? Is it caching things to speed up your responses? All of that is storing information, and it's necessarily not confidential. You need to make efforts to make sure you understand the capabilities of what you're using when you're using an AI product. I hit the wrong button. My apologies. So some of the risks with searching or drafting aspects of Invention using AI systems. These are plainly obvious, but we should say them. Because if you've never actually used one of these systems or you don't have a specialized system, you need to know what could happen. It's as simple as that. And one of the big things is client-sensitive information to third parties. You're breaching your confidentiality obligations to your clients. And that could be as simple as you have an invention disclosure, you believe that everything in there is supposed to be part of your application that you're going to be drafting, but maybe you didn't parse through it. And okay, maybe there's some proprietary information that sort of explains the background to what this invention is. And it should not have ever been introduced to AI. Even if you have a system, it's a trade secret potentially. And we'll kind of talk about how that interfaces. You have to know what's in that invention disclosure. And you have to know that if you have the authorization to work with AI systems from your client, are you asking to make sure that everything is actually supposed to go in that patent application? Because if you blanketly upload that to an AI system, you're risking, divulging that confidential information to who knows where, depending on what system you use. Other issues, national security, export control, foreign filing license issues. It's the same thing if you have other invention disclosures and you're dealing with those issues. Think of it as, this is another system, even like an individual that can read these documents. Can that system be breached? Is it fully secure, right? And then any sort of data breaches. Are you making sure that, whatever enterprise system you're using has backups and has security? Are there physically different locations where the back end is that's actually powering the tool and then where the user inputted data is? It's those sort of issues that can break this obligation and cause a lot of issues. And the truth is most of these issues may never raise their heads. All of us who practice for the USPTO, it's not their job to investigate these things. But do you know where these problems come out? You have a client, you successfully prosecute a patent application, you have a patent. they build a business around it, they start selling their product, it inevitably is making them a lot of money, and somebody wants to rip it off. They start infringing their patent, and you want to enforce the patent rights. That stuff will come out in litigation. That's 5 years, that's 10 years later after that patent's been granted. It might not ever, and it likely won't ever come up when you're dealing with the USPTO. But later down the road, when it means the most to the client because it's driving their business and they want to enforce their patent rights, well, you may have introduced something that might question the validity of that patent. Is it a public disclosure bar? Because you weren't sure about what you were using was in fact confidential. I'm going to tail back around to this because this is something that recently came up: invention, disclosures, and trade secrets. So, as you know, we have patent attorneys and we have patent agents. Patent attorneys, we're licensed state bar, and then patent agents, they have their registration number and they can practice for the USPTO. And the sort of breadth of what a patent agent can do kind of is really limited to the patent practice. I've worked with practitioners who take that very conservatively. So even simple opinions like infringement opinions or patentability opinions, they believe that that's a full legal opinion and they shouldn't be doing it. And I've also worked with other individuals that have a more broader stance on that. Why that's important is because when you have an invention disclosure and there's potential proprietary confidential information that could be subject to a trade secret situation with that company or client, you're not talking about practice before the USPTO anymore. So you necessarily are bifurcating our practitioners that work for the USPTO, because now you're talking about the practice of law. So one of the big things is any individual that failure to identify that proprietary information and failure to confirm the contents of the invention disclosure with the client before providing the disclosure is an input to the tool. I mean, general knowledge of trade secret law is something that both registered patent attorneys and registered patent agents, even though one of them is technically, the attorney, they can practice all types of law versus one is restricted to USPTO practice. It's really important, especially from a supervisory perspective, that if you have both on your team, they need to know the difference. And you're not telling them to opine on it. You're not telling them to give advice to your client on it, but you're making them aware that when they're reviewing an invention disclosure, because you need them to generate a patent draft, right? They need to know that this problem can be there. And if something looks like, ooh, this doesn't really seem related to what we're trying to patent here or what we're trying to apply for, is this potentially a trade secret and should we confirm this with the client? That's being aware. That's asking the question. If you don't know that question exists and you don't ask it, like I said before, it's not going to come up during prosecution. It might not even make it into the patent application, but that information was possibly put into an AI system and it's possibly disclosed. Did you just, inadvertently disclose trade secrets from a company because you didn't ask the questions, because you didn't know that was something you should be aware of? Not only the fact that you can put it in, but the fact that it doesn't belong there in general, right? So as we know, inadvertent disclosures are a big problem. Client-sensitive information, third parties, harms to the client, public disclosure bars can happen, all sorts of different things. All of this is developing. This is all new in our world, and I'm sure in the next 5 to 10 years, we're going to see all different ramifications of people that weren't thinking about these questions to be asked, and they want to just improve efficiency without having a baseline of what the issues could be. So the do's, and they're in order of, okay, better, best. Paid for AI systems, pro version. Don't use a free version, just period. Don't use that. We don't really know how much that's being stored. We don't know how much that's being shared, because especially if you're dealing with large enterprises, Google, Facebook, OpenAI, Microsoft, they sell data. That's part of their business model. You don't know where that information is going to go that you put into a prompt. So you don't want to use any type of free version. kind of the in between here is a closed loop system. I have the pleasure of having a Qthena product, which is from Questel, and it's a completely sandbox system. So whatever's used by myself or other people on my team or other users of the product, it's completely isolated to that one user. And it's actually isolated case by case. So the actual work that the AI does and the learning that the AI does is in another separate server, and it's actually physically distinct from what the users are using. None of it gets trained. One of the problems is you have to redo things because it's not going to remember what you said last time. It's not going to remember your style, format, things of that nature. But that does keep it confidential. And then lastly, some of these tools actually have their sort of settings and inputs restricted to publicly available information. So you can actually make sure that if you want to use the AI product, you have a hypersensitive client, that you can ensure that, okay, I'm only going to use information that's published in the USPTO registrar or EPO that you can actually pull and scrape from the internet. You're not going to input anything confidential. The only things that are going to be looked at is stuff that everyone else can see. So the don'ts, free version LLMs, and any inputs containing potential trade secrets. Know the difference. Here is the 3 big questions that you have to ask. And this will go into our competency requirement because we have to be competent in order to actually work on the field of art that we're prosecuting or we're drafting. But competency actually extends to the tools we use to further the goals for our clients, okay? And so here's the big 3 questions. Does the LLM learn from our data? Do you have an abuse monitoring exclusion agreement with this enterprise? And does this exception actually guarantee no prompt caching, no prompt logging, and no human access? So abuse monitoring exclusion, that's what you should write down. If you are somebody who's on this, who will make a decision for your company, for your firm of whether or not you're going to use an AI product to help your team, ask that provider if they have an abuse monitoring exclusion. All LLMs, all enterprises, Googles have this in there, and they're required to, so they can see if prompts have nefarious, explicit, violent inputs, and they can track those. The problem is under the guise of safety, they are necessarily violating confidentiality. This is where the issue is with your pro paid versions. You still have this abuse monitoring. So even though you paid for a pro version, you're ensured that it's confidential, this still exists. So therefore, it's not confidential. And that's going to be a big problem. So you need to know what this is and you need to ask if you're in the driver's seat to decide whether or not you're going to use one of these tools. After you ask that question, does this exclusion mean that there's no prompt caching? So in a typical AI system that you would download, so Gemini, ChatGPT, could be Microsoft Copilot, they're going to store the prompts in order to speed up generation, okay? If you're storing the prompt, it's somewhere. It's potentially not confidential. So you need to ask that explicitly. No prompt logging. So this is for diagnostic purposes. This is to actually improve the back-end enterprise. If they can log for diagnostic purposes, they're storing the information in the prompts. A prompt could be an invention disclosure. It could be a napkin sketch of an invention that somebody hasn't told anybody and they built in their garage or they're fooling around with. That's not confidential. And lastly, no human access. It sounds like it goes with it, but sometimes there is that employee access. So even if you have somebody that says, yes, we have an abuse monitoring exclusion agreement, you need to ask those 3 questions on top of it. This is just a little screenshot. Oh, hi, Elliot.
I'm gonna interrupt you just real quick, Kevin, if you don't mind, just to remind the audience about the CLE credit. The code for the CLE credit is PATENT and the number 28. Again, That's PATENT and the number 28. Great job so far, Kevin. Take it away, and you have some questions in there if you want to take a look at them when you get a chance.
Yeah, for sure. I think we're going to reserve those to the end here so we can get through. Thanks, Elliot.
Excellent. Thank you.
So what I'm showing you is a screenshot of one of the tools that I preferably use, and this goes back to that confidential information. These are certain aspects where you're only going to be using publicly available data. Maybe because you have a company-wide policy, maybe you have a particular client that's skeptical, or they haven't developed themselves an internal policy, so they can't impart it for their legal service providers. You can use you should be finding out whether or not your tools have a way to only use the publicly available data, so you're not breaching the confidentiality issues. And here's one of them. So in this system, you quite literally can generate these products from the available registrars. Anyone can log into USPTO Patent Center. They can make an account. As long as they have an application number or a publication number, a patent number, they can access the entire image file wrapper. This system does the same thing. It's going to pull all those documents that are available. Those are going to be the inputs or the sources that the AI is going to work on. And therefore, you're making sure that you're not dealing with anything that could breach confidentiality. So we're going to kind of go back here to the duties. I talked briefly on competency. So 11-101. You have to have the legal, scientific, and technical knowledge, skill, thoroughness, and preparation reasonably necessary for representation of that client, and particularly the art that that client is holding within their invention disclosure that they're asking to obtain a potential patent for. So that right there also extends to what tools you're using. Preparation reasonably necessary. So what type of preparation, what type of skill, what type of thoroughness? Do you actually understand the limitations and caveats of an AI tool that you might have? Also, what if you're supervising? Are you able to look at product that you might receive from a junior individual at your firm that you're reviewing? Can you tell by reading some of the disclosure, does this look like it came from a person, or does this look like it was generated from AI? I encourage everybody to actually play around with these tools because they look different. It speaks back to you. It writes different. You can tell the difference. And especially if you have a tool in your firm and you're all using that same tool, it has a general way that it outputs. You should know what that general output looks like, because if somebody just copy and pasted that and it looks like it just came directly from the tool, you as a supervisor have a duty to look at that and supervise your junior attorneys and say, hey, this looks like it came right out of our tool we have. What's the problem here? You need to be able to have the adequate background and competent knowledge on the tools that you're using. It's especially important that now that AI is in the game. It's not used before. Could you understand this type of invention? Do you understand this field of art? Now we have to extend that to the tools we're using. The second part, 11-104, well, it's different, but the practitioner is supposed to reasonably consult with the clients about the means by which you're going to achieve what the client wants to have. Like, what are the objectives? How are they going to be accomplished? And what are you going to use to further those objectives? And explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. This is plainly obvious. You need to let them know you have these tools at your disposal, and you should be asking permission. It should be an opt-in, not an opt-out, because right here, 11-104, we have to actually let them have an opportunity to know what the tool is, what its capability is, and whether or not they want us to be able to use it or not. So again, AI does not fill does not gap fill our technical competency. You can't use it to, fill in whether or not you really know anything about the art. But at the same time, just using AI doesn't mean that you understand what it is, and you might not be competent to use it or to supervise others using it. You need to make sure that you satisfy those two prongs of competency that we have now. So those necessary requirements, here we have 11.101, understanding the limitations of the output that an AI is going to give you. Do you understand where they could hallucinate? And do you have that adequate and reasonable training to either use the tool or supervise others that are using the tool? Do you know enough that you can kind of like pass it with a smell test? And the recommendations is, informed use of AI software, and you want to have opt-out provisions, and you also want to, you want to at minimum have the opt-out provision, but you should be asking permission at the outset. Right here is just a snippet from an engagement letter for a client. I quite literally tell the client at the beginning of representation, I have access to these tools and I would like to use these tools. You can ask me about anything about them, and I would like to have your explicit permission to use them. And you also can opt out at any time. You can ask anything about it. I want to pull it right out in front. I don't want there to be any questions about it later on. It's right there in front of them. And this is standard now. If we start representation, you're going to get this little portion in your engagement letter to make sure that we kind of get that out of the way. Doesn't have to be super advanced, but you have to let them know what's going on. You have to have a discussion, and you have to ensure them with the tools that you're using, you're going to protect the confidential information. So as we all know, when we're submitting and corresponding with the USPTO, when we sign our name and we have a registration number, we're certifying under 1118B that the statements to the party's own knowledge are true and the party performed inquiry reasonable under the circumstances. So if you are going to use these tools, you need to verify. You need to verify that what you put in there and you're using with these tools is accurate. And one of the biggest aspects is, are you able to go back and find where that AI got that information from? Is it available to you because it's citing the sources, or the sources are available because your tool provides that? Or is it completely sandboxed? Or is the AI, because you asked it to cite that, now it's changing its answers because you're asking for backup? Are you detecting that there's some anomalies? Was that a hallucination and now the answer has changed? You ultimately, if you use this tool to assist you and then you sign it, you're certifying that it's true. So you better have a way to verify it. The same thing goes from a supervisory perspective. It might look completely correct, but can you go back and track that back to the invention disclosure that your junior attorney had to generate the draft? It's things like that. Can you connect those dots, and do you know to connect those dots? In that same breath there, AI systems can omit, misstate, hallucinate, confabulate different information. We know of plenty of stories of individuals that have cited fake cases and briefs to opposing counsels, and then opposing counsel used the fake cases for their response, and then eventually everybody gets caught and in trouble. It's so ridiculous that we have to talk about it, but AI is getting so good and so fast that if we aren't constantly saying this in the back of our heads, we can get lured into it. Just like social media, AI is an engagement tool, and it is designed to keep us engaged. So the responses that you get when you're using kind of your general enterprise ones, so you have Copilot, Gronk, perhaps, Gemini, ChatGPT, they are designed to give you answers to keep you engaged, to keep you prompting with them. And because of that design, there can be issues. And that's where you constantly have to verify. Because at the end of the day, if you're going to sign something and you didn't take this seriously and you didn't look through, it could slip. And as it gets better and better and better, we constantly have to say to ourselves, verify, verify, verify. So you have to ensure the statements in the paper are true and to your own knowledge and competence. And that's, again, it's coming back up. Do you have the competence to understand the limitations of the tool that's being used and made based on information that's believed to be true? I know there's a bunch of questions in here. I'm actually going to show a quick video of the tool that I use called Qthena from Questel. And within this context of verifying, the tool has built in a look back option. Okay. And what it allows me to do is I can input certain documents, could be an invention disclosure, maybe it's an office action and some prior art, and it is limited to those inputs. And then at any point, I can ask it, where'd you find this? And so that's what I'm going to show everybody here. This is real time. This is how fast this can be done. And if you have a tool that's able to do this, you can constantly verify what the AI is telling you. So you don't have that concern. I will play this again so we can go back through. As you can see here, I'm just using an annotation tool to sort of show what had happened. So long and short of it, this is a publicly available case. Actually received a grant and a notice of allowance now. Basically, we have a singular unit, and the prior art is showing that there's multiple units. And what this AI prompt is here, and the output is saying that they're not a singular unit. And so I want to make sure that that's true. And what I'm going to do is, if you're telling me that and you're bolding that, so I'm supposed to look at it, I'm going to look it back up. And that's exactly what you're going to see. It's going to show me in that prior art document that it's comprised of multiple pieces. It's not singular. It's not monolithic. Tells me right there, not a single monolithic unit. Okay. I'm going to search that. I'm going to verify it. I'm going to make sure that what it's telling me is true and it came from the actual prior art reference. Did you just make that up because that forwards the objective? Or is that something you saw in the input and made sense for what I wanted to argue against the office action? And there it is, a stacked plurality of flue gas blocks. So right then and there, it shows me you're teaching multiple blocks. It's not monolithic. Exactly what it said could be verified. And it did it in all in what, 20 seconds? That's the type of features and sort of aspects that your tools should have so you can satisfy those ethical requirements to make sure that you're ultimately signing something that is true. It's really easy if you can just back it up with the source documents right in front of you. So we're getting toward the end here, and I am going to reserve some time for questions, but this is just a quick little reference table I made for everybody. Overall theme, 1.56 Candor. AI can omit key facts. You want to verify the accuracy of that. Along with the 1.56, you're going to be looking at that sort of example we talked about for AI-assisted inventions. How do we determine inventorship? 1118 certification. As I kind of just showed you, factual and legal validity. You could have a tool that's going to give you unsupported claims. So you want to make sure that that tool, you can look back. And if you can look back and it can't find where it came from, then that's a really good indication that, I probably shouldn't include this. I shouldn't be using the tool for this aspect of whatever piece of work that I'm using. 11101, competence. Not just our technical competence to perform the work in front of us, but our competence to use the tools that are going to help us perform that work. Misuse due to understanding of AI capabilities. This is not only the user, this is also the supervisor. This is also the person that's going to be making the policies for this, maybe this practice group at a big firm, or you're going to be bringing it to your legal group at your company. You need to know what the capabilities are, what the limitations are, and that's part of your competence requirement. And lastly, 11106, data can be shared with third parties. OpenAI. You know, you want to protect client confidentiality, and you want to be able to parse out if there's actual information that could be a trade secret that shouldn't be inputted into any AI tool. You have to know to ask the question, and whether or not you're a patent attorney or you're a patent agent, you should know the difference, and you should be educated on trade secrets so you can ask those proper questions. All right, so I have a couple questions here. We've got about 10 or so minutes, so I'm going to kind of go through a couple of these and try to put a couple of them out there. So one of our first questions, what if AI says that the inventors can use the invention for a totally different application, meaning a different use? Is there an issue with that? Does that raise to the level of new use invention? I would say no. I would say no. And so one of the big things, and I primarily am really dealing in mechanical, software, robotic, consumer products world. So I could see how this could change a little bit in software. I don't do enough in the pharmaceutical and composition of matter world or chemical world to kind of talk to the, validity of when you're changing use. But I don't think that, at least in my circumstances, in my experience, I don't think it would raise to that level, because a thing is a thing. It's still going to have that same stuff. Um, I think though, if you are making, it could be nominal changes that could actually change the ultimate use. So nominal changes to structure could impart huge changes to function. That might be a question. Um, Overall, I think you have to kind of go back to the example. What was given to the AI, right? And what ultimately did the inventors do? Did they build this thing, reduce it to practice completely, and then actually use it for that new use? I would say you're missing like that conception prong. Because if you're just making something that's already there, you're not necessarily introducing a different application. The invention still exists. You're just using it for something different. Unfortunately, I don't think I can comment deeper on applications in chemical or pharmaceutical aspects. I don't do enough of it, and I don't actually introduce the ones that I do to our AI product. So it wouldn't be something that would necessarily apply, nor do I have experience with. And the two companies that I do work for, they don't have AI policies yet, so I'm not allowed to use it, and they don't use it either. Let's go to 2. So we have a little hypothetical. If an inventor A builds a novel and non-obvious AI model, and then the AI model outputs new inventions, if inventor A is listed on the applications related to the outputs, do you think that could be enough for patenting? Ooh, that's pretty good. I would say we're still kind of in the no, because they invented the AI model. So they built the software. So it could be that system, non-transitory medium, recording medium, something of that nature. Could be the method of the actual steps that the system's taking if you're looking at it from a claim perspective. But I don't think the outputs then are going to qualify, because if you're only simply asking for alternatives, I don't think that necessarily is going to, I don't think you can list that inventor. I don't think that has the Panu factors, all 3 of them, to have a significant contribution. And I don't think you could list a natural person. I wouldn't in that case. I don't think I would. It would depend on, I would have to know more about what was done with the outputs that came from there. I really think the model itself, I mean, it's novel and non-obvious, and assuming we can pass patent eligibility, that's patentable. The outputs, I would say no at this point. Without further inventing. So I'm going to stick on the no on that one. Question 3, examples of patent drafting software that meet these requirements. I've tested at this point 5 different ones. The one that I started with was Qthena. The one that I'm sticking with is Qthena. The main reason even though because there is some aspects, it's very robust. It is a lot of learning curve. You actually really have to learn how to use it. It's not the easiest to get into, but once you understand it, it is the most powerful. It's definitely Qthena. And that monitoring, abuse monitoring exclusion, they have that completely locked down. It is 100% sandboxed. They even have their data centers. They have one in the EU and they have one in the US. So if you have clients that have concerns of where your data is being stored, if it needs to be domestic, you can satisfy that requirements. And as I shown, they have that look back tool. Even if I'm trying to use Qthena to help me a little bit with the detailed description because I'm fumbling through 500 reference numbers that I need to make sure in all the drawings that get mentioned somewhere in the specification, I can look that back up. I can highlight something that Qthena outputs to me. I can select the document that, the Invention disclosure document, and I can literally ask her, show me where you got it from. And I think having that ability right at the beginning, right before you even take something out to your document or to your application, you can look at it with your own eyes, and the source PDF can satisfy a ton of issues, right? New updates with Qthena as well. All the authorities are going to be added as well. So MPEP, we're going to have the EPC articles are going to be added as well. So not only are you going to be able to look at the output based on what you inputted. So did this come from the office action? Did it come from a previous reply? Is it in the prior art? You're also going to be able to actively look back the authorities that allow you to make certain arguments. So can you look back this MPEP section because Qthena is suggesting that you should argue under this section? Okay, that's a great example. Let me go highlight this and let me look back and let me reread what this is again and see if this makes sense. That to me is what you should look for. You want to be able to source everything that AI is presenting you, especially if you're representing a client. Ask any provider, can you show me where you got this from? And if they are sandboxed or they're fumbling on that, that's a huge red flag. You don't want to be using something that right at the outset you can't determine where that information came from. Okay, question 4, Microsoft Copilot. It's on all of our Microsoft systems. And to summarize cited art and to contrast that art to the application we're prosecuting in order to identify potential differences we can raise in our response, raise any ethical red flags as per the discussion. Generally, I don't think so. Okay, this is fact dependent. Situation 1, you are actually in the prosecuting situation. It's publicly available. The image file wrapper is on Patent Center. You can access it. Anyone with a login knowing the application number can access it. There's no problems there. There's no problems. You're literally looking at an application that anyone can look at that's publicly available, and you're looking at prior art, whether it's a published application or it's a granted patent that's available to anybody. So there's no confidentiality issues there. I think you're simply just looking for comparisons, and ultimately it sounds to me like you're just trying to develop a starting point for your argument. I don't see an issue. If we're not in the prosecuting aspect, if we're actually kind of early on, so maybe we're working on a patentability opinion, we have a client that brought us, this known prior art, maybe they have a product they built before, and they're trying to look at this new invention they created or a new product that's not publicly disclosed. You necessarily need to input something to compare it to. That's where you have to make sure that the AI that you're using has those confidentiality obligations. I would not be comfortable with Copilot unless you have one. Let's just say you have a company device, and you can talk with your tech provider within the company, and you can kind of go back to those abuse monitoring exclusions. Can you guarantee that that version of Copilot that is throughout your organization is satisfying those obligations, because that's a case-by-case basis, whether or not the contract that you have to use that product is to that level of confidentiality. Simply ask the question. It may be okay, but now you know what to ask to determine if you can use it in that nature. But prosecuting publicly available, no problem. And that's kind of what AI is for. It's a good way to use it. Okay, last one. Advise your inventor clients to ask those 3 questions. Yes. Yes, I would. One, I think it demonstrates you understand the use of AI. And it shows that you have the competency to kind of ask those questions out of them. I would absolutely ask them. And I do now, because I can kind of sniff it when I get an invention disclosure. As for courts, it's not something I have seen kind of come up yet, but we've been kind of looking for it. I really do think that we're too early in the game. I think it's really going to be a problem coming out probably the next 5 to 10 years. Anyway, that was it. So I hope that helped everybody. That was good. I know it's a lot, but this is just a nice baseline for everyone to get started so that you have just some awareness on the questions to ask, what the basic rules are that you need to satisfy, and sort of, what sort of things you need to look into yourselves. You can use it to help a ton. And now that you have the baseline, you can do it in a way that you're not violating, your ethical responsibilities.
Yeah, great information, Kevin. And there is a lot there, and it's going to continue to evolve. I'll be curious to see what changes if you do this in a year from now, right? So thank you for your time and insight. Just stay with me for a couple of seconds. We have some parting information for you. That is about all the time we have for today. So thank you for joining us. We hope it was useful. Thank you again to Questel for sponsoring the event. If you missed any part of this presentation, it will be archived shortly at law.com. So you can view it again, or you can refer someone to it that may receive some value from it. And while you're on that page, we encourage you to also explore other upcoming and on-demand webcasts that we offer. Remember, regarding CLE credits are approved for California, Illinois, New Jersey, and New York only. Participants seeking credits in other states must apply directly to their CLE board. The CLE code was announced during the presentation in the middle. So New York attorneys must retain the code for their New York CLE certificate. CLE credit is available for approval jurisdictions on the date of the live webcast, which is today. So you must provide the date, the month, and the year. You should be prompted to complete an evaluation form when we wrap up, and you will receive an email with instructions for downloading state-specific CLE certificates. That's all. So thank you, everyone. We hope this was valuable to you, and have a great afternoon.
Go Bills.